press the record button. There we go. All right. A quick introduction. Thank you, everybody, for joining us today. And thank you particularly to the folks from OKT who have put this session on for us. We have Roger Townshend from Toronto. We have Larry Innes from Yellowknife. And we have a couple of other folks who we hope will be joining us shortly. These folks are going to talk to us about Bill C-15, which is the Government of Canada's attempt to establish a process for the domestic implementation of the UN Declaration of the Rights of Indigenous Peoples, which many of us know as UNDRIP. I'm looking forward to hearing what Roger, Larry, and others have to say. And so without more, I'm going to turn it over to you, Roger.
Thank you. So I'll get right into it. UNDRIP, as you probably all know, was adopted by the UN General Assembly in 2007. And at that time, Canada did not support it or adopt it, but Canada later became a full supporter of the declaration in 2016. There have been a couple of previous steps made to move towards the domestic implementation of UNDRIP by, there are a couple of private members' bills by Romeo Shuganash in 2014 and 2016, neither of which passed. The current bill, C-15, is a government bill to establish a process for the domestic implementation of UNDRIP. A comparison of Bill C-15 to the previous bills shows that it's consistent with them, and it has, in fact, some improvements to them. And as of now, the bill is in hearings at the Standing Committee on Indigenous and Northern Affairs. Now, to properly understand the relationship, the purpose and effects of Bill C-15, one has to understand the relationship between international and domestic law in general. And it means different things to say that it's binding in those spheres. If something is binding in domestic law, it means that domestic courts will enforce it by punishing breaches of it, or perhaps ordering compensation for them, all backed up ultimately by the state's policing power. In the international sphere, there's no real equivalent of a domestic court having such coercive power. If something is said to be binding in international law, it means there could be international law remedies for its breach. Those would be things like diplomatic steps or perhaps economic sanctions, possibly even military steps by other states. There are also UN bodies that could publish opinions or reports condemning breaches of international law. But none of those have any direct coercive enforcement power. International law functions by persuasion or by convincing other states to take some action against an offending state. However, principles of international law can become incorporated into domestic law, and at that point, they could be enforced by state courts, as any other provision of domestic law. There are three ways in which international law principles can become domesticated in this way. The first is to use it as an aid to interpret domestic law, which would then nudge domestic law closer to international law. That can only go so far as to clarify ambiguities in domestic law. It can't be used to overrule a clear domestic statute. The second way that international law can become incorporated is if there's a domestic statute that directly adopts it and enacts it. That would give that international law instrument domestic statutory force. And thirdly, some principles of international law are established by custom as opposed to by an agreement. And those that were established by custom are considered as having been adopted into domestic common law. So they're already part of common law unless they're inconsistent with a statute of the state. So it's because of this somewhat complicated relationship between international and domestic law that there has been a move to explicitly implement UNDRIP in Canada domestically. Now, the next bit was going to be UNDRIP's current application in Canadian law. I see Kevin Hille has joined me to my relief. So he was going to talk to that about that next little bit, and then I'll come back and talk to about the relation of UNDRIP and the Canadian Constitution.
So, good day, everyone. Thank you for having me. I think the key issue here is that the bill does not immediately implement UNDRIP, but that doesn't mean necessarily that UNDRIP does not apply. And so I want to tease that out in a few minutes. Unlike other legislation that's meant to implement international obligations and treaties, the bill sets out a process for implementation. Other legislation, like the statute that implements the US and Mexico-Canada trade agreement, that one it's actually called the USMCA Implementation Act, and it's about immediately bringing provisions of that trade agreement into Canadian law. And there are other examples of that. The Department of Justice, in the case of Bill C-15, has been very clear that it does not immediately change operations, policies, or laws. It does not alter Canada's duties to Indigenous peoples, and it does not create new duties on industry when dealing or working on Indigenous lands. So what does it do? And primarily it establishes a process and sort of a two-part process. The first is an internal government review of its own laws, and I'll just read from the bill. The Government of Canada must, in consultation and cooperation with Indigenous peoples, take all measures necessary to ensure the laws of Canada are consistent with the Declaration. And so that we understand is an internal government law reviews process done in consultation with Indigenous peoples. So that's one part of it. The government will look at its law book and take all measures necessary to ensure that they are consistent with the Declaration. The other part is an external action plan, under which the minister must prepare an action plan to achieve the objectives of the Declaration within 3 years. Now, part of what we've said in our commentary, which I think was circulated to all of you, is that it's unclear whether that itself contains a policy and law review, and whether and how it will intersect with the legal review being conducted internally by the government. There's also an annual reporting requirement where a report is to be prepared by the minister and tabled to the House of Commons and Senate annually, updating about the progress in achieving the goals of the action plan. Again, what many commentators have pointed to is who holds the pen on that. Is it exclusively a government prepared report? Or is there an opportunity for Indigenous peoples to contribute to it? So that you have this process for implementation, but what, if anything, does the bill do for the application of the Declaration in Canadian law? Is there any immediate application, and does the bill do anything for that? And I think we'd like to say yes, it does, and it can be modified to make it clearer how it does. So Section 2, Sub 3 says that nothing in the Act is to be construed as delaying the application of the Declaration in Canadian law. So that includes the implementation process. The implementation process should not be taken to delay the application of the Declaration in Canadian law. And Section 4 further affirms that the Declaration is a universal human rights instrument with application in Canadian law. So what does that mean? The Department of Justice has said it won't change anything immediately. There's a multi-year process for implementation, yet the bill, the operative provisions of the bill suggest that the Declaration applies in Canadian law now, and that nothing should be construed as delaying that application. So there are really two ways that it applies now, and we think the bill supports this. The first is as an interpretive aid. The preamble to the bill affirms that the Declaration is a source of interpretation of Canadian laws, and that's confirmed by the Department of Justice. And the courts are already using the Declaration in interpreting law. That's an accepted use of international law. It comes from the presumption of conformity, that the legislature only legislates in conformity with its international obligations. But there's an ambiguity because how international law is used can depend on the status of that international law. If it's non-binding, the courts have taken the position very recently that it doesn't carry the same persuasive weight as binding treaty law. So it's important to clarify that UNDRIP is, while a non-binding declaration, is an expression of binding international norms as applied to Indigenous peoples. It's rooted in binding treaties and conventions, but expressed expressing those principles as applying to Indigenous peoples as opposed to the traditional subjects of international law, which are states and individuals. So it's an expression of law contained in conventions, but also customary international law. And I apologize for my lateness. I don't know if Roger discussed the distinction between customary international law and, okay, so we've already covered that. Great. So picking up on that, the customary international law content of the Declaration, we also say, in addition to being a source of interpretation, the Declaration can immediately apply as a source of law. And that's because it expresses customary international law, which applies directly in domestic law. It doesn't require legislative adoption. It directly forms part of the common law, and it doesn't require the implementation process that is set out in the bill. Obviously, that implementation process will bring laws and policies and operations into harmony with those principles, but the aspects of the Declaration that are customary international law are already the law of Canada. So what are those principles? We've outlined them in our blog, and also sent around the International Law Association's analysis and resolution about what aspects of the Declaration form customary international law. And we say that these are available immediately and apply immediately as a source of law. And the bill appears to support that by stating that the Declaration is a human rights instrument with application in Canadian law, and that nothing, including the implementation process, should be taken as or construed as delaying that application. So again, important to distinguish between implementation and application.
Kevin, can I jump in there? It's Glenn Tate from the Law Society. We have a question, and one of the questions we have is, does the laws of Canada, as it's defined in Section 5, mean statutes only or also common law?
That's a great question. I would take that to include common law, but that's a statutory interpretation question I hadn't really thought through. Perhaps my colleagues have some thoughts on that. And Roger, I believe, is going to be speaking about how the declaration can be used to reinterpret the Section 35 of the Constitution, and that in turn should inform the common law. I mean, certainly international norms and international customary international law absolutely inform the common law, and there's a presumption that the common law should conform to it, or that it forms part of the common law. So I think yes, like a more expansive interpretation to look at the common law would make sense, but I think that the government is really looking at assessing its own statute book and trying to achieve consistency there first and foremost. Perhaps that's something we could direct to the Department of Justice and how they see their remit under Section 5.
Thanks a lot.
I think now Roger was going to speak to the intersection of the Declaration and the Constitution.
Okay. So we've talked about UNDRIP being a source for the interpretation of Canadian law. That's the underlying common law, and that's also explicitly affirmed in the preamble of Bill C-15. And our view is that can and should include UNDRIP being used to interpret the Constitution, including Section 35 of the Constitution, as well as other constitutional provisions relating to Indigenous peoples. We think it would be anomalous if Section 35, which was adopted into the Constitution to protect Indigenous peoples and their rights, would come to actually shield the Crown from the development of those protections to better reflect international law. Now, the court just last year in 2020 reaffirmed that the Constitution should be presumed to provide protection at least as great as that afforded by binding international law. And that was in a case, Quebec, via a numbered Quebec company, which was about the interpretation of the Charter protection from cruel and unusual treatment or punishment. And that's the last in a long line of cases of using international law to inform interpretations of the Charter. Now, in the Department of Justice backgrounder, they accept that UNDRIP should be used to interpret constitutional obligations, but they seem to interpret what they mean by that relatively narrowly. We think the principles of UNDRIP should be used broadly and used to breathe new life into the interpretation and application of Section 35. Now, we note that that is in the opposite direction of some interpretations that are being discussed in general, that's favored by some and feared by others, to the effect that UNDRIP should be interpreted through the lens of Section 35 jurisprudence. For example, those aligned with resource developers tend to propose that the bill be clarified to say that that it should be interpreted through the Section 35 lens. And that is indeed what is feared by a number of pro-Indigenous commentators, especially those on the strongest end of the sovereignty spectrum. Our view is that neither of those positions properly deal with the relationship between international and domestic law. So further on that line, Bill C-15 has an explicit affirmation that the act is to be construed as upholding the rights of Indigenous peoples recognized and affirmed by Section 35, and not as abrogating or derogating from them. That's a standard non-derogation clause language. That means on its face that UNDRIP is not to be used to diminish Section 35 rights, not that UNDRIP is to be interpreted through Section 35. We do, however, in our blog, propose an amendment to solidify that in the face of these opinions to the contrary. Now, this debate about UNDRIP and Section 35 and which informs which is really triggered by concerns about UNDRIP's free, prior, and informed consent, which is usually called FPIC, and whether it's a veto and how that might relate to Section 35, which includes in its interpretation the concept of justified infringement and the duty to consult and accommodate. And those issues arise often in relation to resource projects. Canada initially refused to adopt UNDRIP because the federal government at the time thought that FPIC was inconsistent with the Canadian Constitution and thought it was non-binding and aspirational. So along this line, there are proposals abound that the Bill C-15 should be clarified to prevent the creation of an Indigenous veto or an expectation thereof over resource development projects. Our view is that such interpretations misunderstand both the content of Canadian law and of UNDRIP. It's not a matter of whether there's always a veto or never a veto. In our view, neither Canadian law nor UNDRIP have a categorical sweeping Indigenous veto. But both of them, in some circumstances, do require Indigenous consent, which if you want to call that a veto, you can call that a veto. So I'll explain what I mean by that's already part of Canadian law. The duty to consult and accommodate, as you no doubt all know, arises when the Crown knows or ought to know that Aboriginal title or rights may exist and is considering action that may affect them. It's also well established that there's a spectrum of consultation and accommodation required, depending on the strength of the claim and the seriousness of the impact. And for serious impacts on proven rights, consent may be required. Courts have been clear about that. When the courts say that the duty to consult and accommodate is not a veto, we don't take that as meaning that it's never a veto. We take that as meaning it's not necessarily a veto. But if you have a serious impact on a proven right, then a project can't go ahead without consent. It's not a matter just of going through enough procedural steps, going to enough meetings, reading enough things, checking enough boxes, and then you can go ahead and what you want to do in the first place. That's not what the duty to consult and accommodate means in Canadian law or has been interpreted by the courts. Consider where Aboriginal title has been established. The title holder in that case has the right to exclusive use and occupation of the land in question. And the Supreme Court in Chilcotin confirmed that the Crown must seek the consent of the title holding group for developments on the land. If the Crown doesn't do that, it could only proceed in a way that does not substantially deprive future generations of the benefit of the land, and if it can meet a heavy test to justify the infringement. Simply granting the land subject to Aboriginal title to non-Indigenous people just can't be done without consent. And I'd also want to note that in my view, where there are modern treaties, and there are lots of them in your jurisdiction, the justified infringement doctrine does not apply. I don't believe that that's consistent with the concept of a modern treaty. The aspects that the consent must also be free, prior, and informed are also already part of Canadian law. Courts have made clear in the process of consultation, even when consent is not required, that the Crown must provide appropriate information and must not take coercive action. So when consent is indeed required, those considerations would apply with even greater force. Now, on the UNDRIP side of what FPIC means, it's not an absolute veto either. There's Article 46 in UNDRIP, which does provide for some qualifications and limitations on the rights in UNDRIP. And the UN Handbook for Parliamentarians on implementing UNDRIP distinguishes between when FPIC requires a government to seek consent and when it requires that consent indeed be obtained. So in short, our view is the requirement for consent exists both in UNDRIP and in Section 35, and in neither of those cases is it a categorical veto. One thing UNDRIP does do, though, is to widen the requirement for when governments must seek consent in good faith. And that's somewhat wider than has been set out in the current duty to consult jurisprudence, and that's something that the courts should be addressing as the law, Section 35 law, develops. So at this point, I'm going to turn it over to Jacqueline, who's going to talk about some possible impacts of Bill C-15.
Thanks, Roger. Hi, everyone. My name is Jacqueline Mcmahon. I'm a lawyer at OKT, and I apologize for being a bit late today. And thanks for having us. As Roger said, I'll go over a few impacts that we identified, sort of immediate impacts of Bill C-15. This is before the process that the bill contemplates has been completed. So first off, we've already talked a little bit about this, but stronger source of interpretation. So UNDRIP becomes a stronger source of interpretation for courts. And as Kevin and Roger both discussed, courts are already using UNDRIP to interpret Canadian law, but the language in the preamble of Bill C-15 would serve as a strong signal to courts that they should continue doing this, and that this is the proper course of action, that they should be using UNDRIP as a source of interpretation for Canadian law. We've proposed that they go a bit further and be a bit more emphatic and clear about the legal weight and persuasiveness that the Declaration's principles should be given when interpreting Canadian laws and constitutional obligations. But in our view, even if it remains as it's currently drafted, it still sends a message to the court respecting the use of the Declaration. Secondly, it hopefully would act as a bit of a reset to both Crown and public attitude towards the Declaration. When in 2015, I believe when the previous Harper government was discussing the Declaration, they sent a message that it was both non-binding and aspirational, as opposed to, as we've discussed today, containing binding principles of international law. So if Bill C-15 was passed, then it would be a total repudiation of this position of the previous Canadian government, and should signal to both Crown officials, resource developers, and the public that UNDRIP needs to be taken seriously and also needs to be followed. While there are many substantive legal changes after the review process that would be contemplated by Bill C-15, the bill alone affirms that UNDRIP applies in Canadian law. And we've proposed that the bill go further and actually acknowledge how right now UNDRIP is a source of law in Canada. But again, even if it were to remain as it is right now, it still sends that signal to the Crown and resource developers that the Declaration needs to be taken seriously. With respect to the duty to consult and accommodate process, Bill C-15 could also impact the attitude of Crowns in consultations. So again, it shouldn't really impact how Crowns behave in these negotiations, or in in the duty to consult and accommodate process, because the Supreme Court's already been very clear that the process is not an opportunity to for Indigenous communities to blow off steam before Crowns and proponents go ahead with whatever they initially wanted to do. And the Supreme Court has also been very clear that it's supposed to be a good faith effort with the intention of substantially addressing concerns of Aboriginal peoples whose lands are at issue. That said, that's unfortunately not always the case, and it can sometimes end up being somewhat of an exercise in checking boxes. UNDRIP stresses that the objective of consultations has to be to obtain Indigenous consent. And so even if that consent isn't required, as Roger just discussed, even if that consent is not necessarily required at the end of the process, the declaration changes the objective to needing to try to obtain that consent, which could be helpful in moving officials off of the checking boxes approach. As we've already discussed today, Bill C-15 starts a process of developing an action plan to achieve the objectives of UNDRIP. The plan is to be prepared over the next 3 years, and we've heard a number of criticisms about the length of time, but considering the wide-ranging consultations that would be necessary in order to properly go through the process set out in UNDRIP to implement legislation that impacts First Nations and Indigenous peoples, it would be impossible to implement the declaration without having these wide-ranging consultations, and it's nearly impossible to imagine such wide-ranging consultations happening in a period shorter than 3 years. So in our view, the length of time that's set out is realistic, if not fairly optimistic about how long it would take to properly go through this process. And finally, UNDRIP's, the bill's impact will also be seen at negotiating tables. So many of the principles in UNDRIP are highly relevant to matters that are being discussed in various negotiating tables with Indigenous groups concerning land rights and governance issues, as I'm sure many of you are familiar with and know. And the position that Canada takes at these tables are highly guided by federal policy, which is often at odds with UNDRIP and with Canadian domestic law principles, frankly. So we've proposed changes to Bill C-15 that would have Canada review its policies and as well as legislation to bring them in line with UNDRIP. Right now, Bill C-15 only contemplates legislation. And we've also heard concerns that this bill will actually cause federal officials at negotiation tables to refuse to discuss matters related to UNDRIP and use the process set out in Bill C-15 as an excuse to do so. And in fact, we've already heard of this happening. This seems to be a fairly strange and inappropriate interpretation of a bill that explicitly states that nothing in this act is to be construed as delaying the application of the declaration in Canadian law. That said, we've already heard of it happening and the risk is there. So hopefully if the language in Bill C-15 is strengthened to be directed at policies as well, that can assist with this unwanted consequence. So I think that's everything that we had wanted to discuss. We've also set out in some of the materials that you've been sent around some proposed amendments to Bill C-15, but we've already alluded to a lot of those today, and maybe now would be a better time to hear if there are any questions.
Jacqueline, there haven't been any questions pop up in the chat box.
Okay, would it be useful for me to go through the amendments that we had proposed?
It might be, because the material wasn't circulated. There was a disconnect at our end. So that might be a useful exercise if you want to do that.
Sure, yeah, I can do that. So what I'm going to do is share my screen and actually show the amendments, and then I'll talk about the thinking behind each sort of set of amendments as we go through them. Can everyone see that okay? Can anyone see that okay? Okay, great. So we've set out different amendments that we proposed to Bill C-15. that we think would strengthen it in a number of ways, which we've talked about. So the first set of amendments are targeted at clarifying that as principles of binding international law, UNDRIP should be given the highest persuasiveness and weight in the interpretation of Canada's laws and constitution, and that Canada's laws should be presumed to provide protections at least as great as those afforded by UNDRIP. So that's this set here, these first three, 2 to the preamble and 1 to section 4. And if people have questions about the specific changes in wording, I'm happy to speak to that. Otherwise, there's a number of sets. I think there's 7 sets of amendments, so I'll just keep going through them. The second set here is also to the preamble, but deals with Article 4 of the UNDRIP. So the paragraph this paragraph in the preamble is based on Article 4 of UNDRIP, which talks about the right to autonomy and self-government as part of exercising the right to self-determination. Article 4 of the UNDRIP references Indigenous communities having the ways and means for financing their autonomous functions. So we thought it would be appropriate for that to be included in this statement of the preamble. The third set of amendments here is aimed at clarifying that the UNDRIP should inform the interpretation of Section 35 and not just having UNDRIP being read through the lens of Section 35. So in other words, Section 35 shouldn't read down the UNDRIP, and the language here is how we propose to clarify that in the bill itself, that they should be read together rather than one through the other. And the fourth set of amendments, which start here, also to the preamble. Here we wanted to clarify the connection between treaty implementation and UNDRIP. Our concern was the use of the term can, or the word can, made it seem as though the relationship between the two is optional. So we added language here to be clear that treaties contribute to the implementation of UNDRIP, and that UNDRIP to the implementation of treaties. The fifth set of amendments here. These amendments are aimed at linking sections 5 and 6 of Bill C-15, the action plan to the plan to revise laws and policies. And we've already talked about the reasoning behind that a little bit. The sixth set of amendments, which are here, are aimed at ensuring sections 5 and 6 are in line with Article 19 of UNDRIP, which deals with good faith, which deals with consultations and cooperation in good faith through Indigenous peoples' own representative institutions to obtain free, prior, and informed consent before making changes. And finally, the last set of amendments here are more practical ones, because it is likely, these are changes to the Interpretation Act, and in our view, it's more likely that lawyers and judges and people trying to interpret laws would look to the Interpretation Act rather than Bill C-15, unless they knew about it, to determine how laws should be interpreted. So the proposals here, the first proposal here is aimed at making sure that UNDRIP is used as an interpretation tool for Canadian laws under the Interpretation Act. And then the second proposed change to the Interpretation Act is with respect to the use of must versus the use of the term shall. This is one that we noticed when we were reviewing the legislation. I'm not sure if Roger spoke about this at all before I signed on. Okay, no. So when we noticed when we were reviewing the legislation that the Interpretation Act, in the Interpretation Act, shall is defined as being imperative, but the current act is silent on the use of must. And Bill C-15 uses must throughout as imperative, and we noticed that a number of other acts that are more recent have also used must as the imperative. And while in our view this is positive because obviously must is a much more plain language drafting word. We would like it to be reflected in the Interpretation Act, how it should be viewed when being interpreted, and that it is also imperative. So those are all of the changes that we had proposed. I'm going to stop sharing. I've stopped sharing my screen.
Well, and Jackie seems to be frozen a moment. So, oh, she's back. Are there more questions? We've got some time for questions, or if not, I guess we can all just ad lib, or we can shut down early.
Roger, we haven't got any more questions just yet. We'll give people a couple more minutes to see if they want to pose any other questions. And in the meantime, while we wait for that, first of all, I want to thank all the folks from OKT, Larry, who didn't say much, but I know was instrumental in organizing all of this, Roger, Kevin, and Jacqueline for the presentation. I've asked Larry to provide the materials that these folks have referenced, and we will get them out to you. We will also post a link to them on the recording of this session when we put it up on the YouTube channel, which will be either later today or tomorrow. And Roger, I'm not seeing any other questions, so we'll take that as you've explained everything to everyone's content.
Okay.
All right. Thank you, everybody, for attending. Thank you again to the folks from OKT. Have a good afternoon, everyone.
Cheers.
Thank you.
Thanks, everyone.